watching Bill on Bankruptcy. I'm Lee Pacchia. To my right, we have Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg terminal. Bill, welcome.
Good day.
So our case of the week is about a bank that didn't quite blow the whistle after discovering a customer who was engaged in a fraud. The result in the case from Chicago was entirely different from a similar lawsuit involving Bernie Madoff. Can you fill us in on the details here?
Oh, sure. This is absolutely fascinating, and I'm wondering whether we're at a tipping point in the development of law. Take this as a typical situation, Lee. Assume you're a bank. You have a customer, a corporate customer, and then your bank officers, through their relationship with the customer, begin to suspect, if not flat out know, that the customer is involved in a fraud. The bank goes about its business, maybe continues doing business, but protects itself in case it blows up. Or maybe they discontinue doing business, but in the meantime, keep their mouth shut. Don't tell anybody. Later, of course, the fraud blows up. And then, of course, the bankruptcy trustee or the creditors sue the bank for complicity in the fraud, some sort of a conspiracy theory for not blowing the whistle. In the Bernie Madoff case, the banks were essentially exonerated by the courts, although the issue is not entirely resolved as yet. There was a different result in the U.S. Seventh Circuit Court of Appeals out in Chicago in a case with a really strange turn of events. This involved the Sentinel Management case, where Bank of New York Mellon, as it's now known, was the lender. And the evidence suggests that the bank pretty well knew that the company was misusing customer money that should have been segregated and not used for any other purpose. The issue went higher up in the bank, the suspicions that is, but from what I gather from the opinions, the bank basically said, we're going to go ahead and do business as it is. The trial judge listened to the case for 17 days and ruled strongly in favor of the bank, found no liability. It went to the Court of Appeals, and in a decision by Circuit Judge John Tender about 1 year ago exactly, he had to hold his nose, but he affirmed dismissal of the case. The creditors didn't give up. They filed a motion for rehearing by all of the judges in Chicago. The panel, rather unexpectedly, in December, revoked their opinion and said they were going to think about it again. And then lo and behold, a few days ago, they came down and flat-footed reversed themselves.
Why?
Not only did they reverse themselves, but they also said that, in essence, the bank's lien is going to be voided as a fraudulent transfer. And they also said that it's likely as not that the district court is going to have to determine that their claim is subordinated. A really shocking turn of events from a $312 million secured claim to a claim that's subordinated to everybody else.
What's going on here, Bill?
There are two ways to look at it, Lee. I'm glad you asked that question. On the one hand, it may be simply the Seventh Circuit off on a lark, departing from what other courts typically do in similar situations. On the other hand, it may very well be, as I said a minute ago, a tipping point in this frequently arising legal question. Because, you know, somewhere down in the basis of your soul, you have the sense that if you know there's a fraud going on, you shouldn't sit there and profit from it or do nothing. But on the other hand, there's no obligation in this country to report a crime. At least if you do, and of course you're at liberty to do so, you might get sued, especially if you're wrong and there really was no crime. So running around having a bank being forced to blow the whistle all the time is some pretty serious business. I don't know where this is all going to end up, but this is a very interesting opinion that everybody ought to read, especially banks' lawyers.
Yeah, this is a situation that bears watching for sure. Bill, our videos would not be complete these days without taking some time to talk about the American Airlines situation and the government's attempt to stop its merger with U.S. Airways. What's the latest developments here?
Two things are going on. The federal district judge in Washington will decide in a couple of days when the trial on antitrust will begin. The airlines want it to start in November. The government wants it to start in March. Meanwhile, the bankruptcy judge is trying to figure out, do I or do I not confirm the Chapter 11 plan now? The confirmation hearing was concluded, and American urgently wants the judge to confirm the plan, leaving resolution of the antitrust issues as basically a condition subsequent that will have to be satisfied before they can consummate the merger. I have a feeling that what the bankruptcy judge may do is to issue his opinion on confirmation, but not actually sign a confirmation order. That way, everybody's going to know exactly where he's going to come from. They'll know that once the antitrust issue is resolved, well, then he will quickly sign a confirmation order. We should find out, I suppose, in another week or two whether that's right or I'm way off base.
Very good. And we have a judge of the week. This time it's bankruptcy judge Kathy Surratt-States from St. Louis. She is our judge of the week because, of course, she had a very rough week. Bill, can you tell us why it was quite so rough?
Oh, gosh. You know, Lee, we all have days like this. You know, it's the day when you wish you'd never gotten out of bed.
Sure.
Well, poor old Judge Surratt-States, who is a very fine bankruptcy judge in St. Louis, was reversed by bankruptcy appellate panels twice on the same day.
Oh, man.
Oh, I mean, you know, that's enough to make anybody.
That's pretty brutal.
Oh, it is. I really feel sorry for her because in both cases she wrote really fine opinions. They just didn't persuade the three judges.
You think they coordinate and space it out a little bit, you know?
They should have.
Hold one back if you can.
They should have. One of the cases involved student loans. There was a woman who was only able to earn about $2,000 a month at most, and she had $118,000 in student loan debt. And Judge Surratt-States said you cannot discharge that student loan debt in bankruptcy. The appellate panel reversed her, and in essence, the appellate panel said that you cannot simply assume that somebody is going to have increased income in the future. You have to have evidence, and that is a very important issue because there's almost no cases in which there is any evidence that somebody's income is going to increase over what it has been historically. Mm-hmm. The other was an important decision in the Patriot Coal case where the appellate panel thought she got it wrong about whether Peabody Energy is liable for some of the employee or retiree health benefits.
All right. Bill, let's close out with some advance sheets for the week. Although many lawyers are on vacation in the dog days of August, the U.S. Court of Appeals in Chicago has been busy handing down an important bankruptcy decision. I gather this one is exceptionally important. Tell us about it.
You bet it is. And guess what, Lee? Right back where we started from, this is written by Circuit Judge Tender out in Chicago. This is an entirely different subject matter in bankruptcy. What he is doing is suggesting to the U.S. Supreme Court how they ought to rule on a case that will be argued sometime this winter in a case called Bellingham. And Bellingham is a hugely important case that is going to say whether or not, let's call them Stern versus Marshall objections, can be waived. You'll recall that a couple of years ago, the Supreme Court held that in certain kinds of state law issues, bankruptcy judges do not have the constitutional power to issue final judgments. The question has now arisen, and there's a split of circuits, on whether or not the failure to raise a Stern objection can be waived. And the court split right straight down the middle, one ruling for waiver, one against it. Judge Tender wrote an enormously interesting opinion in a case called Wellness International versus Shariff, in which he said there can be no waiver. And believe me, Lee, if he is correct, that is enormously important. Ordinarily, courts of appeal in these situations would not issue opinions. They would simply sit back and see how the Supreme Court is going to rule in another 6 to 9 months. But methinks that the Chicago court wants to, in some fashion, help the, shall we say, Supreme Court to focus its analysis and perhaps come down in favor of their view that there can be no waiver. The opinion is extremely important. Everybody who makes his or her living in bankruptcy must read it because it goes off on some issues that other courts have not done. For instance, tender decision says that if it is a case that falls within Stern versus Marshall, a bankruptcy judge cannot even issue proposed findings of fact or conclusions of law. And they did something which is even more remarkable in this Chicago decision. They said that if it is an issue that is what's called core, but yet follows under the Stern versus Marshall rubric, in that case, the lawsuit or the dispute must be, and get this, Lee, must be taken out of bankruptcy court and brought up to the federal district court. This, as I say, is also something that other courts have not typically done. So, Lee, go read this decision if you haven't already, and sit back and let's see how the Supreme Court handles Bellingham. The last briefs in Bellingham are due sometime around the end of the year. Means argument should be sometime in the midwinter. Decision maybe sometime around March, April.
Good stuff. Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just discussed, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You'll find Bill's column on both venues. If you'd like to see more of our videos, you can see them on YouTube. And if you'd like to see our updates, you can follow us on Twitter. I'm Lee Pacchia. Thanks for watching.